To do this week is go through the OSH Act. Now, last week we covered administrative law, which basically gave a framework by which agencies like OSHA can operate, and the overview of how the regulatory process works with the influences of the legislative branch, the executive branch, and the judicial branch. This week I want to go through a specific piece of legislation, the OSHA Act, and just kind of give you an overview of it in general. And one of the things that I have in your reading assignments is a copy of the Act itself. And I think it'd be a good idea if you actually read it. You can go to Public Law 91596 and read that off the internet. I have a PDF, like I said, in Canvas that you can look at. But I'm assuming that you're all pretty familiar with it, but I doubt any of you have actually ever sat down and read the whole thing before. It's not that long, maybe 30 pages, so I think it'd be a good idea to do it. Just a little bit of history and background behind it. From the 1930s up until 1970, we did not have formal federal OSHA in this country, but instead what we had was the Walsh-Healy Public Contracts Act, which came out of the Roosevelt era after the Gauley Bridge disaster occurred, where all those people died in West Virginia from exposure to silica. And that led to a public outcry that we need to do more to protect workers. But we didn't have a federal OSHA at that time, and so the first early kind of federal OSHA was called the Walsh-Healy Public Contracts Act. And what it said is that if you do business with the federal government over a certain dollar value, which was about, I believe, $10,000, if you were in a contractual agreement with the federal government, you had to provide a safe and healthy workplace. So from 1930 up until 1970, the only type of federal regulation we had over workplaces was with individuals that had contractual work with the federal government. And in that period, a lot of different types of regulations were developed to make sure that whoever had contractual work with the federal government actually had safety and health. And so there was kind of an early framework for an OSHA from about 1930 to 1970. In the 1960s, there began a more formal process to actually have a law passed which would have national occupational safety and health coverage. And this went through several different versions. The legislative history of this is quite interesting, but sometimes a bill would be passed in the House and not in the Senate. Other times passed in the Senate and not in the House. There's even a version that was passed by both the House and the Senate, and they were unable to agree to in conference committee and died. But finally, in late 1960s and early 1970, there was a version of the bill that was introduced in the Senate by Harrison Williams, a Democrat from New Jersey, and in the House by William Steiger, a Republican from Wisconsin, that was signed into law by then President Nixon. So this did go through a fairly lengthy process to get to the point where we had an OSHA Act. And I think it's important as we talk about some wording within the OSHA Act and reading through the OSHA Act, you'll see some words that are sort of strange, and you'll ask, why in the world did they say something like this? And you have to look at the fact that Williams was a Democrat and Steiger was a Republican, and if you don't think Democrats and Republicans get along today, you've got to go back to the 1960s when we had a very turbulent time in the United States. And to get people who had very different philosophies of the world to compromise required that they to come up with words that they could both agree on to actually get this enacted. So some of the language is a little strange, and the reason for it is that if a word hadn't been changed, you would not be able to get certain members of Congress to vote on the act. And so that is why some of the wording of the act is somewhat odd at times. Well, there were certain agencies created by the OSHA Act. First is OSHA, which is the Occupational Safety and Health Administration. The next is NIOSH. This is the National Institute for Occupational Safety and Health. Then there's two more that you may have a little bit less familiarity with. One is the Occupational Safety and Health Review Commission. And next week we're going to talk more about the Review Commission and what its role is, and we'll go through some specific cases. And the last is the National Advisory Committee on Occupational Safety and Health. So these entities did not exist prior to the OSH Act and were created by the OSH Act when it was signed into law in December of 1970. Now, where are these agencies placed? The main one, OSHA, is placed in the Department of Labor. The other main government agency, NIOSH, is placed in the Department of Health and Human Services. You may ask, why aren't they both within the Department of Labor? Well, it gets back to this compromise. This was a battle to get the OSHA Act in place, and some of the early versions of the bill actually had OSHA placed within the Department of Labor and NIOSH in the Department of Labor. And some opponents of that said, wait a minute, since NIOSH does work to support OSHA OSHA regulations, you could just have the data be skewed. They could be making things that would be very biased to feed to the agency. And to try to alleviate some concerns about NIOSH doing autonomous work and not doing biased work for OSHA, they were placed in different cabinet departments so that there would not be this concern. Who are the people in these cabinet departments? I think it's important to know who the people are. Again, I'm talking to you now. This is October 9th of 2014, and the current Secretary of Labor is Thomas E. Perez. Back during the previous presidential administration, the Secretary of Labor was a Kentuckian, Elaine Chao, and that's me pictured with Elaine Chao back in right before she was appointed to be the Secretary of Labor. This is the current head of OSHA, David Michaels. His title as head of OSHA is Assistant Secretary of Labor for Occupational Safety and Health. And NIOSH, this is John Howard, who's the director of the National Institute for Occupational Safety and Health. He was actually appointed by George W. Bush and reappointed by Barack Obama. So he's one of the few people who has been able to survive two presidential administrations where the presidents were from different parties. Generally, there's a house cleaning that goes on when you have a new election, and especially if it's a change in party. But John Howard has been an individual that seems to be well liked by people of many political persuasions. Now, when OSHA was passed, what were the duties that were delegated to this new piece of legislation? I'll just read this. The Secretary of Labor delegates to the Assistant Secretary for Occupational Safety and Health the authority and responsibility for safety and health programs and activities of the Department of Labor, including the responsibilities that previously existed, such as in the Walsh-Healy Public Contracts Act of 1936 that I mentioned earlier, as well as other pertinent pieces of federal legislation that had been derived to try to address safety and health concerns in other sectors. Like construction, already had some construction safety and law that was passed in 1969, maritime safety in 1958, the National Foundation for the Arts in 1965, and the Longshoremen and Harbor Workers Act also had some safety and health provisions. All of these now became the responsibility of OSHA under the Assistant Secretary of Labor for Occupational Safety and Health. OSHA was given authority. It had the authority to promulgate, modify, and revoke safety and health standards. Promulgate, again, is a fancy word for create a new standard. To conduct inspections and investigations, issue citations, including proposed penalties, to require employers to keep records of safety and health data, to petition the courts to restrain imminent danger situations, and to approve or reject state plans. I don't know if I can move this thing. Yeah, I can move it. Sorry about that. The Act also authorized OSHA to provide training and education to employers and employees, to consult with employers, employees, and organizations regarding prevention of injury and illnesses, and to grant states the funds for identification of program needs. This is the state plan development portion of OSHA. Many states, like Kentucky, have a state OSHA program, and to develop and maintain a statistics program for occupational safety and health. You'll find the Department of Labor regulations, as you're aware, in Title 29 of the Code of Federal Regulations. Title 29, CFR 1910, has a general industry, and the other ones that were incorporated, construction and maritime, are in a different section. And just as an example, if you look at 1910 Subpart G, which is occupational and environmental control, see the noise in 95, non-ionizing radiation in 97, etc. Toxic and hazardous substances like air contaminants in 1910-1000, and then more specific hazards, toxic substances in other portions. There's also regional offices for OSHA. located around the country, regional administrators, and they will coordinate training and consultation, etc. Now, NIOSH is one of the other agencies created by the Occupational Safety and Health Act, and its primary functions are to develop and establish recommended occupational safety and health standards. We'll talk about this when we get into court cases, this word recommended. That means that OSHA does not have to accept what NIOSH recommends or just simply recommendations. It also does research, i.e. conducts experiments and demonstrations related to occupational safety and health, and it develops educational programs to provide an adequate supply of qualified personnel to carry out the purposes of the OSHA Act. We have a small grant here at Murray State from NIOSH to help us do just that. It gets some computer supplies, we have some funds for graduate assistance and some special projects, etc., but it does help smaller programs like ours. NIOSH also transmits their recommendations to OSHA, and it creates criteria documents. And if you haven't looked at these at the NIOSH website, they're actually pretty useful for different types of chemicals and exposures, but they'll include the information that's listed here, how you sample for things, and some of the procedures for control, etc., what PPE you might need. But they're very comprehensive documents on a wide variety of occupational hazards. NIOSH also conducts research, and will do this for new standards. It'll develop criteria. It transmits those criteria to OSHA. It publishes a list of known substances and has health hazard evaluations. And it can be a helpful resource if you need technical information, you want to know more about industrial hygiene or medical services, etc. NIOSH website and some of the individuals at NIOSH can be very helpful in many of these aspects. NIOSH does is it funds educational resource centers. There are 19 of these geographically distributed around the United States, and they contain two of the following four components: industrial hygiene, safety, occupational medicine, and occupational nursing. Sometime in the 1990s, one of the directors of NIOSH was Linda Rosenstock, and up until that point, educational resource centers had to contain three of the following four components, and because of that, occupational medicine and occupational nursing, the majority of these are located in major medical school areas, and that is because it's difficult to do occupational medicine or occupational nursing if you're not in a medical school. She relaxed it to 2 out of 4, and that expanded the number of educational resource centers, but most of them that are in existence were established back when NIOSH was established and have been continued sources of federal funding since then. Here at Murray State, we're under the umbrella of the University of Cincinnati. There's one at the University of Texas in Tyler, University of North Carolina, Chapel Hill. Johns Hopkins has another educational resource center. University of Washington at Seattle. University of Utah at Salt Lake. So they're all over the country, and if you ever think you might want to get a PhD in safety, or industrial hygiene, these are very good places to go because they do have a lot of resources available for you to do research. The other thing NIOSH does is prioritize what kind of research it does. It used to do this in terms of priority areas. Now it has sector councils that are the sectors are groupings that are based on the similarity of occupational safety and health concerns in their workplace. And they will be targeting different areas to look at what kind of research projects need to be addressed. If there's very high fatalities in the fishing industry, for example, they'll come up with some research methods on ways to try to reduce those kinds of problems. So NIOSH is actively looking at the entire U.S. workforce and trying to come up with areas where they can be of best assistance by providing additional information. One of the other agencies that was created by the OSHA Act is the Occupational Safety and Health Review Commission. And we're going to be talking about the Review Commission quite in depth next week, as well as some cases that come before the Review Commission. But right now, just to give you a little bit of the update of what it does, there are 3 members on the Review Commission. These are appointed by the President and confirmed by the Senate. This commission is an independent agency of the executive branch. It's somewhat similar to the Environmental Protection Agency in that regard. Yeah, EPA is not under any cabinet position like OSHA is under the Department of Labor. EPA is kind of out by itself as an independent agency, and the Review Commission is that as well. And the way that this works is its principal function is to adjudicate cases when an enforcement action taken by OSHA is contested by the employer, employee, or their representatives. So if you get a citation from OSHA, and the first thing you do is you try to resolve it in-house with OSHA, with the area director, and there are mechanisms in place to resolve those type of citations. But if you can't resolve them in-house and you're still unhappy with the citation, you can go to the federal court system and sue the agency. But that takes a lot of time and a lot of money. And so what this act did is give people an opportunity to contest their OSHA citations with the Review Commission prior to going to the federal court system. So this gives both parties an opportunity to go before an administrative law judge and talk about what the citation was about and why you were not able to resolve it with OSHA. And the commission will review those and decide, make a decision, and then people have the opportunity of either being happy with what the commission does, or if they still feel that they haven't gotten adequate resolution, then they can go to the courts. But this is a buffer between the courts, and it's has some oversight on what the agency does. And again, next week we'll go through some specific cases, and you'll get more of an idea of what the Review Commission is about. The other group that was founded by the OSH Act, or created by the passage of the OSH Act, is the National Advisory Committee on Occupational Safety and Health. This advises, consults with, and makes recommendations to OSHA. This has 12 members. 8 are designated by the Secretary of Labor, 4 are designated by the Secretary of Health and Human Services. And again, you ask, why doesn't the Secretary of Labor just designate everybody? It got back to this compromise. This is the only way you could get the bill passed, is to have the members selected by different cabinet positions. And the membership is to include representatives from labor, management, occupational safety and health professions, and the public. And if there's an issue that OSHA wants to develop a standard on, this committee is of great help to OSHA, because they survey the workplace and they say, okay, OSHA, you've got a $500 or $600 million budget. You can't do everything. This is an area that we think you need to target your resources. And then they typically will appoint a 15-member advisory committee composed of experts to assist OSHA in the development of the standard. And just for the fun of it, let's get out of here for a second and take a look at the National Advisory Committee for Occupational Safety and Health's website. And I'm getting my spinning beach ball here. Yeah, they have a website on OSHA, and it does have the current committee membership, and that has public representatives. You have a professor from Puerto Rico, someone who is from the Washington State Division of Occupational Safety and Health, management from Johnson & Johnson and Safety Initiatives, health representatives, a professor from Johns Hopkins, someone from Navistar Incorporated, labor representatives, individual from the AFL-CIO, safety representatives from BP and LaborSafe. And so you have representation from a lot of different sectors involved in this committee. And again, this is a very important committee because it helps OSHA target its resources more as effectively as it can. The major provisions of the OSH Act, I don't want to spend a lot of time on this because you can read through the Act and you can see this, but this is just the subheadings, and I know you cover this in other classes. The OSH Act will tell the coverage, the employee duties, employer rights, the standards, record-keeping and reporting requirements, variances, inspections, violations, citation, penalties, etc. And it applies to every employer who has one or more employees and is involved in a business involving interstate commerce. Again, back to this interstate commerce thing that is really the basis for a lot of constitutional basis for a lot of safety and health legislation. And it doesn't apply in areas where other federal agencies regulate standards. And will sometimes see jurisdictional issues, especially with the DOD in certain areas where they have other standards that are applicable to their employees rather than the OSH Act. Then the general duty clause is part of it, that each employer shall furnish to his employees employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to his employees. And a recognized hazard is a condition that is of common knowledge or general recognition in the particular industry in which it occurs, detectable by means of the senses, or of such wide general recognition as a hazard in the industry that there are generally known and accepted tests for its existence which should make its presence known to the employer. And each employer shall comply with occupational safety and health standards promulgated under this Act. You read the Act, that also has employee provisions that employees need to comply with the occupational safety and health standards and all rules, regulations, and orders pursuant to this Act which are applicable to his own actions or conduct. Now, what I wanted to spend a few minutes on here, which you may not be as familiar with as some of the other areas of the OSHA Act, is the standard setting process. And we're going to be revisiting this in 2 weeks when we talk about OSHA in the federal courts, because many of the standards that OSHA has promulgated have been challenged in federal courts. And the wording of this has become really important on what the courts have done in terms of either upholding or vacating the regulation, or giving OSHA guidelines on how they need to prepare standards in the future. And again, we'll talk about that more in 2 weeks. But anyway, just reading from the Act on toxic materials and physical agents, the quote, shall set the standard which most adequately assures, to the extent possible, on the basis of the best available evidence, that no employee will suffer material impairment of health or functional capacity, even if such employee has regular exposure for the period of his working life. And again, this is sort of strangely worded, and you have to go back to the fact that this Act was passed by a lot of compromise. I'll just give you one example on this. No employee will suffer material impairment of health. What does that mean? Well, you ever go to the doctor and the doctor says, I think your health has been material impaired. No, you don't usually hear that particular term. Well, that word was actually stuck in, and we'll talk about this in 2 weeks, by an amendment to one of the versions of the OSHA Act, and the amendment was called the Dominic Amendment. And what it did was it changed the word any to material, because one of the versions said no employee will suffer any impairment of health. And members of the House or Senate were saying, wait a minute, there could be something really, really minor, like a mosquito bite, and we don't want this Act to cover trivial health consequences, so we want the health consequences to be a little bit more serious, and so the word any was changed to material. But that's just an illustration on how this Act was constructed, with a lot of changes that had to be made before everybody could agree on it. And we'll talk about some of these other words later on when we talk about how courts have interpreted them. For example, the extent possible or feasible, and the best available evidence. What does that actually mean, and how has the Assistant Secretary of Labor addressed that when they've been putting together standards? Now, what is a standard? A definition is something which requires conditions or the adoption or use of one or more practices, means, methods, operations, or processes reasonably necessary or appropriate to provide safe and healthy employment and places of employment. OSHA promulgates standards by 3 methods. The 3 methods used are 6A, 6B, and 6C, and now I want to spend a couple minutes going through each one of those different methods. What 6A is the original standards. And these were standards that were created 2 years within the Act's effectiveness. And essentially what this did was Congress said to OSHA, okay, you're a new agency. You're in charge of safety and health standards for the United States, and you don't have any. So for the next 2 years, we are going to allow you to take as many standards as you'd like to and incorporate those as your own. But you can only do this until April 29th of 1973. Then you have to do something different. But you can't just take any standards. They have to be either a national consensus standard, a proprietary standard, or some type of a pre-existing federal standard. So for the first 2 years of its existence, OSHA was very busy going out and incorporating a lot of different standards as their own, provided that they met the criteria of a consensus standard, a proprietary standard, or a pre-existing federal standard. And that window closed on April 29th of 1973, and then they had to follow the 6B process, which we'll discuss in just a minute. But what kind of things did they use? Well, there was the Walsh-Healy Public Contracts Act, and they used that, and they incorporated many elements of that in their standards. They also took the entire ACGIH 1968 TLV booklet and incorporated everything as an OSHA standard. And the sad part is, to this day, the 1968 TLVs are still PELs, and you'll find them in 1910-1000 in the Z1 table. They also took some things from ANSI and etc., but that's an example of a 6A standard. Then there were consensus standards like the National Fire Protection Association standards, American National Standards Institute, and I mentioned ACGIH. Proprietary standards, these would be things like from Underwriters Laboratory, and a lot of other groups that had created some standards before OSHA would incorporate, or could incorporate, and they did, from things like the American Petroleum Institute, the American Society of Heating, Refrigeration, and Air Conditioning Engineers. These are the people that come up with levels of how many air changes you need per hour and relative humidity in the room and what levels of carbon dioxide will be comfortable. Crane Manufacturing Association, American Welding Society, Institute of Makers of Explosives, etc. And then pre-existing federal standards, Walsh-Healy Public Contracts Act, like I mentioned, the Federal Service Contracts Act, Longshoremen and Harbors Act, Construction, National Foundation for the Arts, standards that were already out there that they could incorporate as their own in federal legislation, they could incorporate as their own. And they were very busy doing this for the first 2 years, but that window closed in April of 1973. From 1973 on, they have to follow the 6B process. And this is one of these things that I would have to say that nobody's happy with, because if you go from 1973 to the present, 2014, this process has been utilized to incorporate exactly 30 chemical-specific standards. That's 30 standards in about a 40-year window when you have about 70 or 80,000 chemicals that are registered for use in the United States. And so this is a very slow, cumbersome process that virtually no one is very happy with. But it's the law that Congress gave OSHA that they have to follow, and these are the procedures to promulgate, modify, or revoke a standard. So if you have a standard that's out there that you want to modify, you have to go through 6B. If you want to get rid of it, you have to go through 6B. And this is something that has to go through an informal rulemaking process as prescribed in the Administrative Procedures Act, which we talked about last week, and 6B has to go through this process. Now, what OSHA does is it goes through the following 10 steps. First of all, there's an indication of need. That can come from you as an individual, it can come from your professional society, or it most likely may come from the advisory committee that says, there's a need to have a standard in this particular area. When that's done, they'll request additional information. They'll review all that information. They'll develop a proposed standard, and this may be done by a subcommittee appointed by the advisory committee. They'll review the feasibility, and we'll talk about this in more detail in 2 weeks, but there are feasibility tests that OSHA has to do for standards that meet both technical and economic feasibility. Then they'll publish a notice in the Federal Register that they're going to be creating a standard in this area, and that's when things get interesting. Then you have a public comment period, and in some cases, like in the ergonomics standard or the indoor air quality standard, you had literally hundreds of thousands of people that submitted public comments. And then they have the right to do a public hearing, and sometimes they do this. They don't have to. It's not required by Congress, but as I mentioned in the discussion last week, they can use a hybrid rulemaking policy where they will bring people in and put them under oath and take cross-examination, and that may or may not occur. Then once this is done, the Assistant Secretary has an opportunity to revise the standard based upon the public comments that they receive and then go through a promulgation phase. Now, one thing I do want to point out about this is all done in-house. Congress has already authorized OSHA the ability to create a standard by this particular process, and so once they get to promulgation, this is not something that Congress votes on and the President has to sign into law. This is done by the Secretary of Labor, all in-house at that particular time. So this is an internal process done through the agency and the Department of Labor. The last way that OSHA creates standards is by 6C. And 6C standard is an emergency temporary standard. This is where a, quote, grave danger exists as a result of employee exposure to new toxic substances, harmful physical agents, or new hazards, and an emergency standard is necessary to protect employees from such a danger. With an emergency temporary standard, you do not need a notice and comment rulemaking period, which is a good part, but the downside is it expires in 6 months, and after 6 months are up, if you want to make a standard, you have to go through the 6B process. And in 2 weeks, when we talk about some of the court cases, we'll talk about the vinyl chloride case. And vinyl chloride is an example of a chemical that had an emergency temporary standard issued on it, and at the expiration of the emergency temporary standard, the agency went ahead and promulgated a new standard lowering the exposure to vinyl chloride. What types of standards are there? There are emergency temporary standards that we just talked about, permanent standards, performance standards, design, and either horizontal or vertical. A permanent standard applies to everybody, general industry, maritime standards, construction standards, agricultural standards. A performance standard is like a PEL. This sets a goal, i.e., it gives you a level, and OSHA doesn't care how you get there. You can substitute out the chemical. You can build a better ventilation system. Just as long as you get to that level or remain below that level, they're happy with that. So that's a performance standard. A design standard is much more specific. This requires a ventilation system or something like that to be installed and meets a specific design requirement. Horizontal standards are those which apply to all workplaces and relate to broad areas, whereas a vertical standard applies just to a particular industry with specifications that relate to individual operations, like textile work platforms, or bakery equipment, or sawmills, or some things on this list that just apply to that industry and no other places. Now, I mentioned earlier that the process of creating standards is pretty slow, and this is especially problematic in my area, which is chemicals, in that we've had only 30 chemicals that we've had PELs created since OSHA was in existence, and for the most part, the 1968 TLV booklet, which has I think about 450 different chemicals in it, are still the OSHA PELs. Now, the TLV booklet is revised every year, and so the TLV booklet of 2014 looks nothing like the TLV booklet of 1968, but the 1968 TLVs are still PELs. And again, no one is very happy with this at all. And OSHA wasn't either. So back in 1989, they said, well, we took all of ACJH's TLVs before, let's do it again. And so they revised all the PELs based upon the 1989 or 1988 TLV booklet. And anyway, they tried to do that. They went to court and they lost. And the reason that they lost is that the appeals court told them that OSHA, Congress provided them a process to promulgate standards, and that was to follow the 6B process, and they violated it. They have to go through each chemical and go through the process of doing a feasibility study, get a public comment on it, etc., before they can revise a PEL, and you just can't do this en masse. You have to do it on a case-by-case area, and therefore the 1989 new standard promulgation was overturned by the appeals court. There are currently a lot of discussion in the safety and health community on what we can do to revise the PELs. There have been suggestions from revising the OSHA Act to executive orders issued by the president to try to update the PELs. But it is a problem in that, for the most part, most of the chemical-specific PELs are still derived from the 1968 TLV booklet. And again, I kind of went ahead of myself, but the appeals court overturned this because OSHA failed to establish that the existing PELs in the workplace present significant risk of material impairment, and the burden of establishing the new PELs were not met for the technical or economic feasibility, and therefore it was vacated in 1972. And the Justice Department decided not to appeal and instructs OSHAs to use the PELs that were in effect before 1989. One thing that I did want to talk about a little bit is what I call the strange case of ergonomics. And this is kind of an interesting case because in the 1990s, a standard on ergonomics was promulgated, but it was vacated. And normally, if you revoke a standard, you have to go through the 6B process. But in the case of ergonomics, the 6B process was not used. So the question is, how did you get rid of it? And that's why I'm going to talk about what I call the strange case of ergonomics. And I'll just go through and tell you a little bit how this worked. But in 1996, the Senate unanimously signed into law an act called the Congressional Regulatory Review Act. This is also known as CRA, and it was tagged on as a provision to Small Business Regulatory Enforcement Fairness Act of 1996. And what this Congressional Review Act stated was it provided a 60-day window for Congress to reject final regulations issued by federal agencies. Now, this didn't mean any regulation issued by a federal agency, but the trigger for the CRA was that if a new regulation had an economic impact of more than $100 million, or if it required a major increase in cost or prices for consumers, or if it significantly had an adverse impact on employment, productivity, competition, or investment, this would trigger the CRA, which meant that Congress, if it so chose, could review that agency's new regulation. The federal agency that was promulgating the rule would submit a report containing a copy of the rule, a concise statement relating to the rule, and the proposed effective date of the rule to each House of Congress and the Comptroller General's office. And if Congress didn't like it, they could issue what was called a joint resolution of disapproval, which would be referred to the Committee of Jurisdiction. And if they got 30 senators to sign this position when it's introduced, it bypasses the committee and is immediately placed on the legislative calendar. And once it's on the calendar, the leader may move to it at any time that they so wanted. Some rules for the process is it was debatable for 10 hours, equally divided. No motions or amendments are in order, so you couldn't filibuster it, and a vote on a final passage will occur at the conclusion of the debate, requiring only a simple majority. If both the House and the Senate pass the joint resolution of disapproval and the President signs it, the regulation may not be reissued, quote, substantially in the same form. Well, what happened in ergonomics? Well, the OSHA issued an ergonomics rule on the final day of the Clinton administration, which was January 20th of 2001. Subsequently, on March 6, 2001, the Senate voted on a joint resolution of disapproval and passed it 56-44. The next day, the House voted on the joint resolution of disapproval and passed it 223-206. And 2 weeks later, President Bush signed the joint resolution of disapproval into law on March 20th of 2001, which, as we see in the previous slide, means that the regulation may not be reissued, quote, substantially in the same form. And this is the only time that the Congressional Review Act has been used since its enactment in 1996. Ordinarily, if there's a regulation that Congress wants to get rid of, or the President wants to get rid of, they can't. They have to sort of prod the Director of Secretary of Labor or the Assistant Secretary of Labor to follow the 6B process along the lines of what we talked about earlier, and it has to go through the complete 10 steps. This was an exception, and it was such a notable one that I thought it was worth at least mentioning to you. So that concludes my discussion on OSHA, and next week we'll talk about the OSHA Review Commission.